What if you had something, and this something was to be kept private and confidential, and you wanted to tell someone about that something, but not a lot of someone's, but one someone whom you trusted in confidence, and say you wanted your something to not be seen as just a little something, but a big something, and you didn't want it disclosed, not just yet, but when you were ready. But what if that someone was threatening to or did tell everyone about your something? This is called a breach of confidence, and you can take action for this breach. This equitable doctrine has a long history of case law, with cases that typically provide protection for the secrecy of an idea, like the tools to make a leather pouch or the engine design of a moped. But what happens when your confidence is broken in a more personal way? Let's talk about two very important contemporary cases. We will go back to 2008 with Giller and Prokopets. This Victorian decision was a landmark case. Briefly, it is important to understand what happened to the distressed Miss Giller. Mr. Prokopets had videoed himself and his then de facto partner, Miss Giller, having sex. The first time it was recorded was in secret, but later videos were recorded with her consent. When the relationship ended, Mr. Prokopets showed these videos to Miss Giller's family, friends, and employer. What is interesting about this case is that at first instance, the Supreme Court did not allow Miss Giller damages. However, on her appeal, the Court of Appeal held that there was no reason why she should not recover damages for the distress she suffered. The second case is 2015's Wilson and Ferguson. Ms. Wilson and Mr. Ferguson met at work and began to date. As part of modern dating, they sent each other raunchy photos, being part or completely nude. Ms. Wilson had on her phone videos of herself nude and one where she was engaged in a sexual act. On an occasion, Mr. Ferguson sent the videos of Ms. Wilson to his phone and after an argument agreed that the videos would be kept in private for only his viewing. When the relationship ended, Mr. Ferguson posted the videos to Facebook, which was seen by 300 of his friends, some of whom worked with Ms. Wilson. Distraught, Miss Wilson was unable to return to work and suffered severe financial loss. The Western Australian Supreme Court granted an injunction against Mr. Ferguson for posting any further photos or videos of Miss Wilson. They also awarded damages to Miss Wilson in respect of her financial loss and for her distress. What do these cases mean for personal privacy rights? While there continues to be no recognised tort of privacy, these cases highlight a trend that the Australian courts recognise modern breaches of confidence. Even more so that information can be considered as property. What is also interesting is the development of recovered damages by the plaintiffs in the form of compensation. In both cases, equitable compensation and aggravated damages were awarded for the purpose of putting the innocent party in either case to position they would have been before the breach occurred, but no exemplary damages were awarded. This is highlighted by the compensation for distress in both cases and the financial loss suffered by Miss Wilson. So, can I sue if someone discloses my private or personal something? Yes I can. If I disclose someone's private or personal something, will I be liable to pay compensation? More than likely, yes I will. Especially if there is distress and financial loss because of the breach. So be careful with whatever you do. If you don't want everyone or don't think that everyone should see it, hear it, or replay it, don't share it. Because personal privacy rights have come a long way and are here to stay. This video was made for the 2015 Summer Intellectual Property class for QUT by Benjamin Alexander Oatman.